Asylum status is a form of humanitarian protection offered by the United States. Raju Law, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.
Hello everyone, and welcome back to the weekly live session held by attorney Raju Mahajan and Associates. For today, I am your host, 𝗂𝘂𝘆 𝗟𝗶𝘆, and our guest is none other than the founding attorney of our firm, Mr. Raju Mahajan himself. Mr. Raju Mahajan, it's great to have you here.
Thank you very much, Orchita, and thank you everybody who are watching our show at this moment.
Thank you so much. Today, audience members, we are going to talk about a very important topic, one that I'm sure a lot of you are curious about. For today's live session, our topic of discussion is the U visa. Mr. Mahajan, please enlighten us on this.
Thank you very much. Can I see this presentation? Okay, thank you. So again, I welcome everybody to our show. And today we are going to talk about EU non-immigrant visa. It's a non-immigrant visa. First of all, a lot of people, they think they will get green card through EU visa, which is not true. Definitely, if you qualify for other kind of green card application, you may go there from EU visa to those kind of application, like for example, VAWA or other thing. But EU by itself, it's a non-immigrant visa. So it will give you only authorization to stay in America for 4 years. You can do legal work here. You can invite your family member, but still it's a non-immigrant visa. Next slide, please. Okay, so the question is, what is a EU visa? So the purpose of EU visa is to encourage victims of crime to help the law enforcement to investigate and prosecute crimes without the fear of being deported from the US. So the bottom line is, if you are a victim of crime, and I'm going to talk about all those crimes shortly. So if you are a victim of one of those crimes, and if you have information that may help law enforcement and US government to prosecute those criminals, accused criminals, then they will they will issue you EU visa to stay here, and then you can help the law enforcement to prosecute the matter. Next slide, please. All right, now the question is requirements of EU visa. Victims of any of the following crimes could qualify for a EU visa if the crime took place in the US. This is a very important information. That's why I put like an underline of this. So the crime must took place in America, within America, and that includes all the territory, American territories. So a lot of time I get question from prospective clients that the victim and the accused, both of them are living in America at this moment, but the crime took place in a foreign country. In that case, you are not qualified for EU visa. There are other kind of process for that, but you will not be qualified for EU visa. The crime must take place in the US. Now the question is, what are the crimes? And there's a list here, but remember that this is not all the crimes. Even if there's like other kind of crimes not listed here, you will also be qualified for EU visa. So bottom line, they cover pretty much all kind of crimes. It starts with rape, torture, trafficking, incest, domestic violence, sexual assault, abuse, sexual conduct, like all kind of crimes. I'm not going to read everything because number one, there's a slide here you can see. Just remember, pretty much any kind of crime is covered under EU visa. Next slide, please. However, just because someone was the victim of one of these crimes does not mean that she or he will automatically qualify. They have to meet the other requirements to prove and establish their position. So just because you're a victim, you're not qualified. Again, there are some other requirements. The applicant has, so one of those, like two of those requirements are, the applicant has information about that crime. You must have information about the crime, and it was helpful in being helpful or is likely to be helpful in the criminal investigation or prosecution of that crime. So you must have information, and the information must be helpful to the law enforcement agency. Only in that situation, you will be able to qualify for EU visa. Next slide, please. What is certification from law enforcement and how to get it. So this is one of the most important document to get visa, like U visa, is you have to get a certificate from law enforcement agency. And the question is how to get it. So the following officials and agencies may be able to provide the law enforcement certificate. The name of the certificate is Form I-918 Supplement B. Remember this, I-918 Supplement B. So a lot of time what happens is they just get a letter from law enforcement. That will not work. You have to take this form I-918 Supplement B form to the appropriate authority. They will fill it up, sign it, and send it to you. That is the proper mechanism that is necessary for U visa application. It can be federal, state, or local law enforcement agencies. It can be prosecutors. Prosecutors are lawyers. Basically, they are government lawyers who prosecute the matter. Judges, the presiding judges can also fill up this form, or other authorities that are responsible for the investigation. Again, these other authorities pretty much cover everything in law enforcement umbrella. I'm not going to go in that detail here, because in the purpose of this show or this video is just information only. This is not a legal advice, just information. So I'm not going that detail into here. If you have any question or concern, you can always reach out to us. We'll be able to help you. Here, just information. Next slide, please. All right, what refers to substantial physical harm and mental harm? So this is another very important information regarding U visa, because just because you are a victim of a minor crime, it will not give you U visa. You must suffer substantial physical and or mental harm. So USCIS will consider several factors when deciding whether the harm was substantial, including any permanent or serious harm to victims' appearance, health, or physical or mental well-being. Substantial harm can be showed through a victim's personal statement and through supporting evidence, such as medical report, declarations from mental health providers, and a statement from professionals or friends or family who have helped the victim since the crime. So, here you can definitely submit a medical report, like a doctor's note, also like mental health providers assessment, or even like friends and family who helped the victim since the crime. All this can be part of evidence to establish that you suffered physical and or mental harm. But you have to establish that. Just because it was a minor crime but you did not suffer any physical or mental harm, that it will not work. Next slide, please. Validity of a US visa. So U visa. U visa is offered for 4 years initially. In rare cases, the U visa status can be extended beyond 4 years, but only if additional time is necessary due to exceptional circumstance, or if the certifying agency provides a new certification specifically stating that victims' presence in the US is required beyond the 4 years. So again, usually we'll get it for 4 years. In some rare circumstance, it may be extended, but usually not. Just remember, it's for 4 years. And within these 4 years, if you qualify for other kind of visa application, definitely you can change of your status from U visa to other visa. Or if you qualify for green card, you can go for adjustment of a status to green card application. If you qualify for those, you can do it. Unless you do qualify for any of these, then you have to leave America after 4 years. Next slide, please. All right, work permit on a U visa. A U visa holder gets 4 years work permit immediately after approval of U visa. Here is a catch here: immediately after approval of U visa. At the time you apply for U visa application, you also submit application for work authorization. And a lot of people, they think as soon as I apply for this U visa, I get the work authorization. That's not true. First, you have to get the U visa approved. Only then they will give you the work authorization. Usually they do both of these together, meaning when your U visa application will be approved, immediately after that you will get the work authorization, usually within 1 or 2 weeks. It doesn't take a lot of time, but you will never get the work authorization before approval of the U visa. Next slide, please. All right, applying for family members. U visa applicant can apply for his or close family members as derivative. Again, there's a lot of discussion about family members who are qualified, who are not. I'm not going that detail here because this is information purpose only. Just remember that U visa applicants can apply for their close family members, meaning parents, siblings, children, spouse, those kind of people. So, just remember that part. Next slide. Now the question of U visa application process and required documents. This is very important. So you have to fill up Form I-918. This is application for EU non-immigrant visa status. Form 918 Supplement B. Remember, I talked about this before. Supplement B is you must fill it up and signed by law enforcement agency, any kind of those that we discussed. Also Form I-192, the waiver of any ground of inadmissibility. I'm not talking about grounds of inadmissibility in this discussion because that kind of applies to any kind of visa application. Just remember that you also have to be, you cannot be within the scope of any grounds of inadmissibility. And to establish that, you have to submit Form I-192. Also Form I-765 for work permit. You can also apply for work permit under this application. Along with these forms mentioned above, the applicant must send USCIS a personal statement that describes how he was victimized. This personal statement is very important. Also, she suffered substantial physical and mental harm as a result of the crime, as I discussed before. Also, you have to submit a statement that you were helpful to law enforcement and willing to be helpful if needed, meaning your information was helpful, and in future, if the law enforcement agency need your help, you are happy to help them. So these are the application process and required document. You fill up the form, you provide all the supporting documents, put it in an envelope, send it to the appropriate USCIS address properly. Next slide, please. Now the question of fee and processing time of EU visa. So there are no fees required to file for a EU visa application. However, some of the other forms within the package may have USCIS fee, for example, work authorization fee. However, in many cases, you can also apply for waiver of those fees. In general, most of the EU visa applicant can apply for the entire package without any fee, but you have to show the reason for waiver of those things. In general, it's free. Now the question is how long it takes. Typically, USCIS takes 12 to 18 months to process this visa. That was our discussion today. Thank you very much.
Thank you so much, Mr. Mahajan, for that enlightenment. I'm sure we have all learned a lot about U visa and its different kinds of characteristics. While you were presenting, an audience member has already presented a question for us. So this question comes from Mr. 𝗟𝗏𝘃𝗲, and he says, thank you for doing this. By how many months do you think EB2 ROW will move forward when the new fiscal year in October 2023 starts? I know it is hard to predict, but just wanted to know your guess. Thank you.
Well, it's my guess. It's everybody's guess. In my opinion, since the immigration year is from October to September, it will move a little forward. I don't know how long, probably a couple months, 3 months, maximum 6 months. I don't think it will move more than 6 months because there's a huge load of immigration applicants every year. So in my prediction, this retrogression will be prolonged. But short answer to your question, probably 6 months.
I hope that answers your question, Mr. 𝗟𝗃𝗲. Up next, we have a question from Mr. Mahmudur Rahman, and he asks, I am willing to change my visa status from F2 to F1 with your consultancy firm. I have already received my offer letter for the fall 2023 and want to start my processing as soon as possible. QS1. Question 1. We have 70% of the 1-year tuition cost in our bank account in the USA. My elder brother will be the sponsor for the rest of the amount. Is it enough to show the exact 30% amount from his account, or he needs to show more than that? Question number 2 from Mr. Rahman is, how can I make an appointment with your firm very soon?
I'm answering the first question. Officially, yes, you can show the financial stability for at least 1 year of the tuition and 1 year of your living expense. So you have to show the financial capability of 1 year of tuition and 1 year of living expense. If you show like exactly 100%, that's okay. But I always recommend show a little more because if you show exactly 100%, it kind of raises a question that probably you're not capable of providing a little more if there's any medical condition or any other kind of condition. So bottom line, short answer to your question, I recommend showing a little more than exactly 100%. Question to your second answer to your second question. You can go to our website. There's a way to book appointment, paid or unpaid, to talk to me. If you see that there is no nearby slots, you can email us, but it depends on my availability. So you can email us and see if there's any availability within next 1 week, and probably I'll be able to talk to you. If not, then you have to wait for the regular calendar mentioned in our website.
I hope that answers your questions, Mr. Rahman. Now, Mr. Mahajan, we have some questions that we have collected from our archive emails. So I'm going to read those out for you to answer. The first question comes from Shubrata De, and they ask how to respond to a notice of intent to deny from USCIS for non-peer reviewed publications as evidence of original contribution.
It is very hard for me to answer this kind of question, without seeing the documents. If USCIS send you a letter of motion to, what is the term he used?
Notice of intent to deny for non-peer-reviewed publications as evidence of original contribution.
Exactly. So if you get this kind of notice, I advise you to talk to attorney and let them handle the situation. It's very hard for me to answer this question without seeing your actual petition, all the supporting documents and everything. So I advise you to contact the immigration attorney as soon as possible.
I hope that answers your question. Up next, we have a question from Ms. Farhana, and she asks, if an F1 visa holder has any kind of disputes from his or her school, employer, landlord, then what kind of legal steps are open for them as per US law?
So as per the US law, all US international students, F1 visa holders, enjoy the same requirement, same legal standard, and same procedure for all the American laws. But most of those laws are state law. So the state you are living, you have to follow this law. For example, if you have a dispute with your landlord, there's a landlord-tenant law in your state. You have to follow that. And you have 100% similar right to a US citizen or US permanent resident. So do not feel like, oh, I'm an international student, I may not have the same right like other people. You do. So you have to follow the same course of action. You have to follow the same procedure to take any action. It could be domestic violence, it could be landlord-tenant issue, it could be employment issue, it could be any kind of issue. So I advise you, and me as an immigration attorney, I do not practice in those kind of law. I only practice immigration law. I am licensed in Washington, D.C. and Maryland. So if it is within Washington, D.C., Maryland, and Virginia area, you can email me. I can handle with the help of some other attorneys. But if you're living in other states, I advise you to contact a local law in that field. Like if it is a landlord-tenant issue, you have to contact a local landlord-tenant attorney. If it is a employment issue with your university, then you have to contact the employment attorney in your area. So bottom line, you have to contact a local attorney in that specific area.
I hope that answers your questions, Ms. Farhana. Up next, we have a question from Mr. Shagor Ali, and he asks two questions. Number one, in 2019, I complete my 4 years diploma degree on electrical. At present, I'm working with an American company in California as a freelancer from Bangladesh for more than 2 years. So can my American employer apply for my EB3 category visa? Question number two, does my academic degree and above job experience qualify me for the EB3 quality skilled category job application? Mr. Mahajan, your thoughts, please.
Yeah, the answer to first question, yes. EB3 is pretty much everybody in this world qualifies for EB3. This is like the best thing about EB3. Everybody in the world qualifies for EB3. So yes, your California employer can apply EB3 for you. The second question is your academic background qualified for EB3 skilled? So I have to determine that based on the job you're performing. Every job in America has a requirement. If you fulfill those requirements, then you are qualified. If you do not qualify for those, then you do not. Like, for example, the work you're doing from Bangladesh, if there's a requirement of a bachelor degree, then you do not qualify because you said you have a diploma degree. So it depends on the job. It depends on the location. I have to check what is the Department of Labor requirement for this job. If you need more information, you can reach out to us. Someone from our firm will sit with you and see what is the requirement and what is your background, and then we'll be able to tell you whether you qualified for this EB3 skilled category or not. But for EB3 unskilled, everybody qualifies.
Thank you so much, Mr. Mahajan, for that response. Up next, we have a question from Ms. Nazia Khan, and she asks, do the EB3 non-skilled and EB3 skilled category visas have different processing times? I heard that EB3 file processing time is faster than the non-skilled category EB3 applications. Is this information true?
Yes, that is true. It depends on, any EB3 application has 3 steps. The first one is called PERM, the second one is called I-140, and third one is either I-485 or IVP, depending on where you are at this moment. So for the EB3 skilled and EB3 unskilled, first 2 steps are the same. It's the same processing time and same everything. However, for the third step, visa bulletin has a different category for EB3 skilled and unskilled, and usually EB3 skilled moves faster than EB3 unskilled. So yes, there is a different processing time, and EB3 skilled is faster than EB3 unskilled.
I hope that answers your question, Ms. Khan. Up next, we have a question from Ms. 𝗦𝘂𝗍𝗏, and she asks, I would like to get admission for my son in the US for class 9. So can your firm help my son's admission in a school for the US? The second question is, at the time of my son's visa interview at the American Embassy, Dhaka, can we, mother and father and son, also apply together for visa as a guardian of our son?
Short answer to the question. First question, yes, your son can get admission to USA as a 9th grade student. Remember this important information. Number one, American education system has multiple ways. There's a public school, there's a private school, and there's a private chartered school. So if your son wants to get admission to a public school, which is cheaper, mostly free, then he can only study there for only 1 academic year, usually from August to May. However, if your son wants to get admission to a private charter school or private school, then he can study as long as he wants. But usually charter schools and private schools are more expensive. That's why a lot of people, they want to go to public school, which is only allowed for only 1 year. So the short answer to your question, yes, your son can get admission to a US school as a 9th grade student. Second question, no, you or your other children cannot get a dependent visa under this 9th grade student visa. You have to find a local guardian for your 9th grade student son, and the local guardian will be the guardian of that son. You, your spouse, your other children cannot be dependent. You can apply for visit visa, USCIS or embassy may approve it or not, but it's not guaranteed.
Ms. Johra also had another question, the final one, which is, my last question is whether my son can apply for both private or public schools for class 9 in the USA from Bangladesh.
Yes, as I said, for public school, he can only study here for 1 academic year. For private school, he can study as long as he graduates.
I hope that answers your questions, Ms. Zohra. We have another audience member who has asked a question, Ms. Sharmeen Khan, and she wants to know about EB3 visa.
Well, it's a big question. EB3 visa is as I said, it's an immigrant visa. You can apply for green card for you and your family members. There is EB3 skilled, semi-skilled, and unskilled, and usually it takes like 2.5 years to 3 years, depending on many factors. And it requires employment. So if you get employment from America, then your employer would be the applicant, not you. You are the beneficiary. We have a video. We have multiple video about EB3. So I hope you will watch this video from our YouTube channel or Facebook page, and you'll learn more.
I hope that answers your question, Ms. Khan. Before we log off today, Mr. Mahajan, I wanted to ask you one final question. Are there any updates regarding immigration policy?
Yes, there's a lot of updates. Thank you so much. Let me go there. Okay, yes. The first is USCIS provides guideline on employment authorization document based on compelling circumstances. So this is a very new thing, and this is going to help a lot of people who already applied for I-140 and got approved, mostly NIW based or other based. So if you have a approved I-140, you can apply for work authorization based on compelling circumstance. Remember, it's based on compelling circumstance. Not everybody qualifies for this. Only if you have a compelling circumstance. I'm not going that detail about compelling circumstance here because it depends on person's background and other thing. But there is another very vital information about this thing is you must be in a valid visa in E3, H1B, H1B1, O1, or L1 non-immigrant visa to get this benefit. Not everybody who even have a compelling circumstance qualifies for this. You must be in a valid visa in E3, H1B, H1B1, O1, and L1 non-immigrant status to get this opportunity. So 2 requirements: you must have a compelling circumstance and you have to be within those visas. The next news is DHS resigned prior administrative termination of temporary protected status designation for El Salvador, Honduras, Nepal, and Nicaragua. So this is a very good news for Nepal, Nicaragua, Honduras, and El Salvador regarding their TPS, temporary protective status. So if you need to learn more, please go ahead and learn. I'm not going that detail about this news. Another good news, UCS expands premium processing for applicants seeking to change into F, M, or J non-immigrant status. So if you need to change your status to F visa, it could be F1, F2, it could be M1, M2, it could be J1, J2. Now you can apply for premium processing. So beginning June 13, that we already started, USCIS will accept for I-907 request filed via, of course, proper on paper or online. It will cover F1, F2, M1, M2, J1 or J2 status who have a pending Form I-539 application to, change non-immigrant visa. Beginning June 26, that is coming up next. You can also, beginning June 13, those who already applied for those kind of change status, now you're qualified for premium processing. Those are applying new application. Your premium processing will start from June 26. I think that will help a lot of people for this. Next is USCIS announces expansion of citizenship and integration grant program and the opening of the grant application period. I'm not going that detail about that. July visa bulletin also shows 3-year retrogression for India. So, a lot of time, like Indian people, they have been waiting for a long time. So every month, a visa bulletin get published. So I request everybody to follow every month's visa bulletin to see the latest update in the retrogression. That was our short immigration update for this show.
Thank you so much, Mr. Mahajan, for that. Ms. Khan has asked another question in the meantime. Are there any trusted agencies that from where we can apply for EB3 visa?
Well, trust is a personal thing. You can trust anybody you like. So we have an organization called Great American Recruiter. They are our sister organization. We process all of their immigration legal matter. So if you want to contact Great American Recruiter, that's a trustworthy organization in my opinion. And their website is www.greatamericanrecruiter.com. You can reach out to them. You can give my reference, and they will talk detail about the EB3 process.
I hope that answers your question, Ms. Khan. With that, I would like to thank Mr. Mahajan once again for his time, for his invaluable knowledge. Also to the audience members for watching, for interacting. Thank you so much. And we will see you all at the same time again next Sunday as well. Thank you very much. Have a great day.